Your original hometown dealer, Saida, Trudeau Chrysler Jeep Dodge and Ram.
One of the violations at issue is Mr. Blundo's failure to properly disclose his conflict of interest regarding an agenda item that came before the County Commission in violation of NRS 281-420 subsection 1. The Nye County Commission was responsible for adopting policies governing how local businesses could apply for and receive COVID relief funds. After the initial adoption of these policies, Mr. Blundo submitted applications on behalf of his business to receive relief funds. Knowing that he had submitted these applications on behalf of his business, Mr. Blundo attended the November 10th, 2020 Commission meeting, at which one of the agenda items was the amendment of one of the policies regarding one of the programs that he applied for funds through. When that agenda item came up for discussion, Mr. Blundo disclosed only that he held a liquor license and that he was utilizing the programs the commission was setting policy for. However, Mr. Blundo also then misrepresented that he did not have a direct pecuniary interest in the policy. Mr. Blundo voted in favor of the amendment to the Nye County's CARE Act policy, which had the direct effect of increasing the amount of funds that his business received by $35,000. Mr. Blundo failed to provide the public with sufficient information to inform them how his private interest would be affected by his vote to increase the CARE's funding limits. To be sufficient, Mr. Blundo was required to disclose to the public that he had applied for funding on behalf of his business under the same program at issue, and that a change in the policy of the program, and especially an increase in the funding limits, would have a direct pecuniary impact on his business and therefore himself. Further, as the sole owner of his business, the pecuniary interests of that business are imputed to Mr. Blundo under the ethics law. Mr. Blundo's statement that he did not have a direct pecuniary interest in the CARES policy was therefore incorrect. The effect of this statement was to portray to the public that Mr. Blundo did not stand to financially benefit from the county's care policy or any change in that policy. The disclosure therefore failed to meet the requirements that it reasonably informed the public regarding the effect of his vote in favor of the amendment on it and what that effect would be on his personal private matters and associated interests. The evidence in this matter shows that Mr. Blundo repeatedly entered the Nye County Finance Office through a staff-only entrance, remained in staff-only areas that are not accessible to the general public, and he demanded assistance from county staff without scheduling an appointment, as was required for members of the public. The evidence further shows that Mr. Blundo behaved in a way that caused county staff to believe they were required to provide him with special treatment in processing his CARES applications, or else their jobs may be at risk. Mr. Blundo's behavior was so disruptive and upsetting to county employees that several quit as a result, and the county's comptroller had to lock the staff door entrance and provide Mr. Blundo notice that he was no longer welcome in staff areas and must only interact with her regarding his CARES applications. Mr. Blundo also made numerous phone calls to Nye County staff to discuss his CARES applications, including a 40-minute phone call regarding an application for rental assistance that had been denied, and that had been denied by the comptroller. During that call, Mr. Blundo used his public position to pressure the comptroller to change her determination denying his application. The comptroller testified that Mr. Blundo's behavior during that phone call caused her to believe that her job could be at risk if she did not reconsider the denial of the application. Again, Mr. Blundo was not prevented by his public position from seeking assistance from county employees on his applications. He was required, however, to comply with the requirements of the ethics law by ensuring he did not use his public position to benefit his personal interests. The evidence shows that instead, Mr. Blundo used his public position to pressure his subordinates to provide him with special treatment. Summary judgment should therefore also be granted as to this code section. These same facts also support summary judgment in favor of the executive director as to Mr. Blundo's violation of NRS 281A 400 subsection 7, using government time, property, and equipment to benefit his and his business's significant personal and pecuniary interests. The undisputed facts show that Mr. Blundo improperly accessed private, non-public areas of county offices and repeatedly insisted on receiving county staff time not available to members of the public to benefit his own significant pecuniary interest. Summary judgment is therefore also warranted in the favor of the executive director as to this violation. As requested in our motion, the executive director is respectfully requesting that the commission grant his motion and find 12 violations of the ethics law against Mr. Blundo.